Good morning, everyone, and welcome to the Wednesday morning seminar. Today we are looking at the problem with subcontracting is, and this is led by Mohammed Haque, who is barrister, adjudicator and quantum expert. And as you can see, his contact details on the screen there. During the session, if you would like to ask a question, please feel free to use the Q&A or chat facility in the bottom toolbar, and I will endeavour to answer as many of these as possible as time allows at the end of the session. Alternatively, if there's something you'd like to ask him, but you don't wish to ask it in an open forum, please feel free to email him directly there, mohammed.haque@fletcherday.co.uk. Okay, Mohammed, I will hand over to you.
Thanks, Julie, and morning to everyone who has joined us already, and obviously others will join as I go along. And today's topic, the problems, should be the topic. Let me just check what the topic is. The topic is the problem, as if there's one problem. No, I would say, even if we call it the problem with the subcontracting, there are many problems in subcontracting, from entering into a subcontract to complete and reclaim from the contractor. So when we talk about subcontracting, the first thing to remember is that presupposes that two parties, the contractor and the employer, the client of any project or scheme, already has a contract, and of course the employer or the contractor will have another set of contracts, primarily the employer, with the professional team as well. So there are three types of contracts we should keep in our mind. One is the employer contractor contract, sometimes we'll refer to as a main contract. And then, of course, the contracts between the employer and the professional team. And if it's a design and build, or for the design portion, which is contractor's duty, there is contracts between the contractor and the professional team. But other than that, for various parts of the scope, the contractors employ subcontractors, and our today's topic relates about the issues around that. Now, the purpose of such a contract is to get some part of the scope done, and generally the purpose of a contract is obviously to record what the respective obligations of the parties are under the contract, and what's going to be the consequences if either party fails to perform in the way that it's a misperformance, or fails to perform at all. And then, of course, it will also include if there are any excuses for non-performance. So that's more or less are the purposes a contract draftsman or the parties have in their mind. And when you talk about subcontracts, what happens, practically speaking, many a times, it happens with the contracts as well, main contracts as well, that our parties or clients, they come back and say, I just asked, where is your contract? You want some advice. Where is your contract? And the response is, I don't have a contract. So that's a problem we need to deal with. Basically, a contract could be recorded or entered into through or via a deed. It could be in writing, it could be evidenced in writing, it could be oral, and of course, regarding by deed and the rest of the types, there's only one thing for our current purposes, or two actually. I will discuss the second one when I'm going to the formation thing, that are relevant for making a difference between by deed and all other types of contract. But people tend to believe that contract is a formal written document, even if not a deed, at least a formal document in writing. Mind you, there isn't any such requirement of English law. Historically, it's rather contracts which are not in writing. The document of the doctrine of contract is applicable, or the laws of contract is applicable when the contracts are not in writing. So just because you don't have a document which you refer to a contract, it doesn't mean that you don't have a contract. So what actually people tell me when I ask, where is your contract? They tend to say that I don't have a written contract signed. Sometimes even if if a written document is exchanged and accepted orally, just because it's not been signed, people think it's not the contract. But that's not the thing. A contract is a simple arrangement between two parties in where one party makes an offer in the technical language, or one party makes a proposal. In our case, for construction subcontracts, the contractor makes a proposal or the subcontractor makes a proposal to perform certain construction activities or items or operations or works items for a given sum, and that's it. That's a contract. As long as and for our definite or within a definite period of time. So there is a time element in it. There is a price or a sum element in it. There is a scope or a list of activities or items of works in it. And if all these are agreed between the parties, then that's a contract. You don't need a deed. You don't need a written document. You don't need evidences to prove the contract. It could very well be agreed orally and can be traced from conduct, like the subcontractor has been invited to the site and he performed what was asked to be done. So automatically the subcontractor is entitled to payment for what he has done as per the agreed sum, or if there is a change or a variation under the contract, then that's it. You know, the price sum or the items will be changed and impact will be calculated, provided, and he could be penalized, or the contractor may take some damages if they have defined liquidated damages within the contract and the contract was delayed, the agreed date of performance was not met. So that's more or less, you know. So forget about the idea of a written signed document with the contract. It could be verbal, it could be by conduct, it could be evidenced in some correspondence, it could be in writing, and occasionally, and in many cases, it could be by a deed. And the significance of entering into a contract via a deed is there is an execution requirement, because deed is a legal document defined under a statute. So execution should be in a particular manner. And so it doesn't matter that the contract says that it's via deed till you have executed it in a particular manner, sealed, signed, and in front of the and two witnesses. It's not a deed, and also there's a stamp duty requirement as well, but doesn't have to be on a stamp paper, but by deed. And then if you do so, then if you are in breach, you'll be a longer limitation period for bringing a suit applies, which is 12 years. So before you commit yourself, you the subcontractor or the contractor, to a contract which is by deed, you have to keep in your mind how long you want to keep the other side responsible, and accordingly take the PI as well, you know, professional indemnity insurance as well for that period, which you have in your mind. If it's by deed, it's 12 years, and if it's by normal contract, it's 6 years. So that's one difference. And the other difference is a contract by deed, ever since Pinnell's case, never needs a consideration, a doctrine of essential requirements of an English contract. So that's another thing. And if that's the case, that's the case. But other than that, as we'll see, we have discussed offer and acceptance. We also need consideration for a contract to be a contract and an intention to create legal relationship. The word intention to create legal relationship simply means that the parties have intended that if either party is in breach, they can go to some kind of resolution machinery. Historically, the court, but nowadays, of course, ADR is the more popular one. And the presumption in the industry is, since construction contract, if it's a business contract, that means one of the parties are not a consumer and using or the services of the subcontractor or the contractor, which is very unlikely because the subcontractor is between a contractor and a subcontractor. Both of them are business people. So if the parties are in business, then the presumption is that every single contract they've entered into or the sets of obligations they have committed to each other are to be construed as a contract because the parties had an intention to create legal relationship in the sense that if anything goes wrong, they will have the right to take the recourse of law. So that's intention to create a legal relationship. I've left consideration. Consideration is the price or the sum agreed for the subcontractor to be paid by the contractor, and the performance of the items of works and other obligations like providing an insurance and things like that by the subcontractor to the contractor. So the contractor employs the subcontractor because they want from the subcontractor the performance of the scope and other obligations, and the subcontractor takes on the employment of a contract because he wants his money. He will perform it and he wants his money. So that's consideration in a practical term. And yeah, I've defined intention to create a legal relation. Let me go back to the formation factual and certain legal points there as well. In the ideal kind of scenario, a tender is sent to a subcontractor with a request to submit its quotation, and normally the employers, they send a draft contract as well with as a part of their tender package. The subcontractor either takes off the quantities price, or there is an activity schedule, the price of, there is a specification and drawing their pricing, their price, that specification and drawing, taking off the quants and taking into consideration the limitations of this site or any specific obligations the specification document includes and any legal obligation it has, and then send back the quotation. If the quotation has found favor, then an order is issued by the employer for the subcontractor to sign and return. So that in that document, everything is included, every single scope, price, specification, everything is included, and we call them in short contract documents, where you have to go to, I'll come back to that in on a later slide, but that's what is signed and sent back. And of course the contractor then signs it. Whether he sends it back or not is a different issue. Practically, and many a times they don't, but then they ask the subcontractor to go to the site. And that's more or less how the contract is formed. And if the subcontractor, having sent the quotation, even not even receiving an order, goes to the site and start performing, from that conduct, unless he excludes it by express words, shows that the contract was agreed. So only time he can say, no, I haven't agreed to the contract or the offer, or I never offered, or even if I've received the order as the offer, I haven't accepted it, or even if I have made the final offer, the other side hasn't accepted it. When can you do that? If you say that if you're the subcontractor, and if you say I've rejected it. So for instance, the subcontractor quoted, let's say, X sum of money for the scope of works and asked for a Y amount of time. And then the contractor came back and says, no, I can only give you W as a sum and Z as or Z as your time to perform it. Now that's not an acceptance. That's a counter offer. Okay, counter offer. Alternatively, if the contractor says no, I'm not going to give you anything because I've got a better deal, and your quotation is rejected. On these two occasions, of course, no one can say that the contractor in this case has accepted it. Okay. Now, if later on the contractor then for some reason says, okay, fair enough, I said things earlier, now you come to site and do what you need to do because I agree now, then that's another offer. And it's for the subcontractor to consider again, and he has the full freedom either to go and agree to that, or to say that, no, I'm not interested because you have earlier rejected my offer. So that's something might happen, but as I said, if ultimately the parties have negotiated and they even at some point they say something like that, but then there was an invitation to come to the site, there could be a contract, whether it's been entered into through a model form or a bespoke form or amendments to it. That's a different issue, how to find out the terms of the contract. But it's pretty sure, because the scopes were there, the price or the sum was agreed, or a system was adopted by the parties to ascertain what sums that's going to be. Let's say there is a rate chart and a schedule of rates, and it's agreed that whatever amount is quantity of things are done, the payment will be accordingly like that. There could be even a standing offer contract, meaning that there is only a framework type thing that under which, as and when there is a call to perform, the subcontractor will perform, and there's a mechanism through which the payment can be asked. That's fair enough. You don't have to be a single sum to be a contract, and it can, as I said, be very much inferred from the conduct. The key conduct is an invitation was made, and when there is a certain scope or a duration has been agreed, and a system is adopted through which the entitlements can be ascertained, that's fair enough, unless it's a letter of intent, and we'll see what that is. So the problem number one again could be, I don't have a contract because there's a letter of intent. So letter of intent is something different from a contract, and although the subcontractor is invited to go to the site and do things, it may not be a contract if the parties have made it absolutely clear that it was a letter of intent. When does it happen? It happens many a times that for some reason or other, certain scopes are not yet clear, has not been ascertained or defined, or not been decided even sometimes whether things will be done, but some other works are needed to be started to meet dates of the main contract. So the contractor, they invite that whilst we are negotiating the terms of the subcontract to be ultimately entered into, we need certain works to be done, some enabling works or some minor works or some works preliminary or grounds work and all these, which this same subcontractor is doing. So what they do, they send a letter of intent saying that come on board and start working, and usually they put a cap on the final sum you can ask for, and it's always different from the terms of the intended contract, and more importantly, it's not a contract at all. It's not a contract at all. So how do you get paid? There isn't any payment entitlement other than on a quantum merit basis. We'll see what a quantum merit basis is soon. But certain other features, since it's not a contract, there's no duration. There's no duration involved in it. There might be, but it's not necessary that you agree a duration or a contract sum. Okay, what's safe for the parties is to agree at least to a schedule of rates. If you do so, and if you give a preliminary idea of the quantities you're looking for, or the items of forex you're looking for, and then identify the quantities, or ask the or state that whatever quantities is performed up to this much, we will pay that, that's good enough. I'm suggesting both the contractor and the subcontractor to have this document ready when they're issuing a letter of intent. And a letter of intent is normally, or ideally, it should become a contract when it's replaced by a formal document being issued by the contractor, normally the case, following the procedure laid down in the document of letter of intent. If that's been spelled out and that has not been done, that letter of intent is not a contract at all. So you may have a written document which is treated as a letter of intent. Ultimately, you find out that it's only a letter of intent, it's not a contract, yet you'll not have a contract. You may not have a written document at all, yet you'll have a contract if that's the situation, that's what you have agreed to. So it's confusing, but for you, as if you're a contractor or a subcontractor sometimes, but it's not to a professional, because these two are completely different things. And as I say, the letter of intent is, the general view is it's not a contract normally. So the other significance of this is, or incident to this is, you do not have an automatic right of entering payments unless specifically agreed. So be aware of it. If you have the phrase letter of intent somewhere on your document, you've got to think of your cash flow. It's beyond the Housing Grants Constructions Regeneration Act. So that's what it is. And of course, as I said, I will discuss quantum merit in the next slide, but there's no issue of delay, extension of time, or liquidated damages either, unless, of course, no one can stop you, that you can have a LOI and define that if this item is not performed within this time period, you need to either send an extension of time and that be granted, or you ask for liquidated damage. But the default position is, no, these concepts do not apply because these are contractual concepts and letter of intent is not a contract. Coming to the next point, I don't have a contract, problem number one. What is quantum merit? Quantum merit is a philosophy, first of all, that if you ask me to do something, and if I do, and if that sort of conduct are thought to deserve some payment, then on a fair market value principle, I should get paid. Otherwise, there will be an unjust enrichment or unjust benefit, or there will be a quasi-contract. That means the law will infer something in sort of a contract, or there is, the doctrine of equity will say, there is a resulting trust, meaning that the guy, the person who has supplied the work, or perform the scope will be the owner of the works, because he's the one who spent money on it at the request of the other, or money and efforts on it at the request of the other. So the core of it is the request. I mean, Anson, a very famous contract professional, who's got the Anson's law of contract, defined that if I'm sitting on a train and somebody comes in and polishes my shoes and then asks for money, he can't, because I haven't asked him to do that. But the matter is completely different if someone has requested somebody that, can you polish my shoes? It's the same example here. If the contractor hasn't asked the subcontractor to come on board and perform some scope for which it's understood in the industry that a payment is needed, in that case, if something is done, that may well be a gift. But if the request is made by the contractor to come on board and perform something, regardless of whether they've agreed something as a price or not, it will be injustice if, or there'll be an unjust enrichment to the contractor, or he would be said by law as receiving an unjust benefit for which he should pay under the doctrine of equity of constructive trust or resulting trust. So all these is the basis of the philosophy of why, or the reason why the subcontractor will be paid. There is an alternative, though. That's again a problematic thing, that occasionally, I'm not saying it's every time is the case, if it so happened that a letter of intent is issued, and then time to time the parties or the contractor has asked and added tasks to the for the subcontractor, and all the works have been completed, and duration were discussed, or if it's completed, it's no more an issue. If it was not discussed, but a mechanism can be found through which the price can be ascertained, or the sums payable can be ascertained, then it could very well be that although it started its life as a letter of intent, it will be construed as a contract by conduct if, in the most likely cases, the scope's different from what was in the letter of intent. However, my request is, this is a problem. It continues, because even if you go to an ADR, you do not have a right to adjudicate if it's a letter of intent. You do only have a right to adjudicate or go to court of law to enforce the bargain under the laws of contract if it's a contract. So why bothered to keep a problem like that? If you are going to the site with a letter of intent, make sure you are only performing those which are included into your letter of intent. And if something else, then clear it up. Either the contractor or the subcontractor should stand up and say, look, we are doing it under an ad hoc contract basis, as and when requested, the scope is requested, and try to agree a price as well, so that you don't have that problem. So that's it. And then the second problem starts. Assuming that we have a contract and the parties are very clear on their mind that they do, what are my obligations? And when I'm saying what are my obligations, I mean both the contractor and the subcontractor. Of course, we can also complicate it by asking who can demand the performance, and I will touch upon that. But let's establish the basic position. The parties to the subcontract is always the contractor and the subcontractor. And if I've referred to the model form, and if a particular model form is there, which has been agreed, then the obligations are written as terms, and of course a few documents which are called contra documents, like a specification, like a pricing document, like a program, if it's a contractual program. All of these are referred to within the model form, and that forms part of the contract as well. So let's say if it's a what you call a JCT contract, for example, we have the agreements, meaning the recitals, the articles, the particulars, the conditions, and then, of course, the schedules. And then, of course, the documents are referred to, like the pricing documents, like the specification, like a program, if it's a contractual program. So all these are contra documents, and that's where you find out what your obligations are. And again, when I ask to my clients, the subcontractors, the contractors, where's your contract? And let's say it's a JCT, what they said to me is, at the most, the recitals, the articles, the particulars, and sometimes the particulars are not filled in properly, and then that's it. No, that's not your contract only, and it could very well be the obligations are written into the conditions to the contract. And even if you send the conditions to the contract, what they do not do is sending me the attached contra documents, such as the pricing document, such as the document which defines the scope, the specification, and already referred to. So what I'm trying to point out is, many a times, although we enter into a contract and we think, okay, we've signed, this is the signature page, so that's the end of it. There isn't anything else in this contract, but no, that's not correct. Loads of documents are, referred to within different parts of the subcontract. And all of these are express terms or obligations of the contract, either because it's on the face of that document, or a document which is referred to and incorporated by reference into the contract or the subcontract somewhere, And then there is another important thing, that's the order of performance. For example, again, let me take the example of the JCT, that if you are entering into a JCT contract, and if an obligation is for the employer or for the subcontractor written into the conditions, or the recitals, the agreements, the particulars, conditions, anywhere, and then if you refer to a document somewhere within the contract, then make specific the order of priority. Okay, if it's the ideal situation is to add these incorporated documents at the recital and refers to it, that it takes a priority over conditions or other things if there is a conflict. That's the ideal situation, and many a times this is missed. And what happens, there contain even not a reference to a particular document. So although it is part of the contract, there is a conflict between the recital, articles, particulars, and conditions, and one of these documents which are somewhat external and only referred to, then the conditions or the articles or the provisions of the main contract will prevail. So in other words, you need a review to understand actually, and ideally speaking, the review should be done by a professional before the contract has started, and who can also give you a streamlined kind of a spreadsheet to describe different obligations that you have or you are trying to impose. So whether you are a contractor and a subcontractor, it doesn't matter, but you got to think that manner, and that's something frequently missed. So the first thing is to try to ascertain the express terms of the contract and different parts of it, the contradictions that you may have. And one thing I've seen in particular, that although sometimes the pricing document, the BOQ, it's rare these days, but not impossible, of course, but activity schedules, all the focuses are there. People frequently miss the specifications and time-related obligations. So why do I say people frequently miss? Is because when they create a program, they do it in a very haphazard manner. They do not take into consideration that whether time associated with every activity and the logic, the way it's been scheduled, is 100% correct. If you go to the employer's professionals like the project manager or the architect, they say, no, that's not my headache. It's the contractor's headache. If you go to the contractor, I said, look, I mean, if it's an NEC, I will handle it when I do the latest program. If it's a JCT, they say, look, it's not going to be taken seriously, so I'm not interested. That's one of the root cause of problems, you see. Later on, you find out, because programming and duration is not a theoretical exercise, it's a practical exercise. It relates to your supply chain, it relates to availability of men, material, machinery at the right point of time. I'm sorry I said men. It's difficult to say human being, or labors, materials and machinery. That's a more neutral term. I'm sorry about that. I shouldn't have said like that, men. But anyway, so that's what you need to ascertain at the very beginning. The second thing is, even if you have ascertained the express terms, there are two things. One is, normally it says always in the condition somewhere that the subcontractor is both the parties are required to perform the obligations as contained in any statute, delegated legislations means other type of, non-parliamentary statutes, and then other laws, and even standards and practices and whatnot. So it's not always that the bare express terms contained within the contract document, which you see up front, is your total extent of liability. It could very well be hundreds of documents got involved in it and statutory provisions got involved in it, because it says that the performance are always subjected to. And then there are other terms, regardless whether this clause is there or not within the conditions that you are to perform, or the parties are to perform their respective obligations under the general laws of the country. There are overriding terms. For example, the Supply of Goods and Services Act. In every construction, and many constructions, it's an obligation for the subcontractor. Every construction contract, I said, it's an obligation of either party to procure goods, and in many, it's the responsibility of the subcontractor to procure goods. And as soon as you are procuring goods to supply, to be installed or used into the an item of works, be it tiles or other fittings or bricks and plaster bolts and some roofing materials, you come under an obligation to comply with various legislation. As I say, Supply of Goods and Services Act requires you to supply goods complying with the implied terms and conditions which are obligatory. So it's just because the contract says a particular way, it's going to be the case. No, let's say health and safety legislation is an important thing, and of course you got to find out who's going to hire the tools or who's going to bring the tools into the site. You got to think about or include in your subcontract. If you don't see them, then you raise the question either side. I'm talking, it's not only the subcontractor, that who's going to handle these issues, the site facilities, the preliminaries, meaning the use of the things which are not specific to a particular item of works, and also a common thing in construction contract is to know your risks. For example, if you're a subcontractor, let's say you're a grounds work subcontractor, okay, and the contractor has sent you a particular piece of grounds report, and then also say that you are the specialized subcontractor, you should know better, so do not rely on it, okay? And you have actually relying on it, found that it's a normal subsurface and digging is okay, it's not going to pose much of a problem. You walk into the subcontract site or the site itself, and you set up your digging machinery and plants, and you find that there's a huge concrete bund underneath, which was not identified in your grounds condition report. And then you find out that's actually a facility of a third party, let's say Thames Water. It's a sewage, and you cannot even touch it. What's going to happen? The responsibility, if you need to divert and do something else, entirely sits on you. That's the default position. You, I mean, the subcontractor. There's no obligation for the contractor, if he has been smart enough to exclude the liability, or even if it hasn't excluded the liability, the risk lies with you. So even if there is a different scenario than what has been accepted or expected by the parties when they entered into the contract, if the risk lies with a particular party, in that case, they will be responsible for it. Similarly, let's say if there is asbestos on site, the health and safety legislation and other legislations dictate that that's the responsibility of the contractor. Okay, so unless he has contractually transferred it to the subcontractor, the risk remains with them. So you open the site, you find elements of asbestos. That's a change. That's a variation. It doesn't matter that you haven't spoken about it earlier. So the same site condition, if it's regarding asbestos, it's one result. If it's regarding something else at the subsurface, it's a different result. So you should do a risk profiling review before you enter into the contract. And my request is spend some money on it, do a budget, and get a pre-contract review and clarify these things when you are finally entering into the contract. You'll not have or have less problems with the obligations. Let's say similar thing applies for valuations. You know that Housing Grants Constructions Regenerations Act has allowed us and make it an obligation for every contract to provide for interim payments. And it also says, the Act also says, that it's for the parties to decide how many payments they want in during the period of the contract. Now, I, for one, had an interesting experience. This was against Balfour. There's no problem because this is or a privacy issue here, and I was representing the subcontractor. And what happened? There was a schedule of payments, interim payments. And it was a sizable contract for my client. I said to them that, look, there is all possibility, or at least there was already a 7 months performance under a letter of intent. So I said, there are all possibilities that the contract will be delayed and there will be overruns. So let's add a sentence at the end of the schedule that if there is an overrun and an extension of time is granted, then or it's considered that an extension of time is, the subcontractor is entitled to an extension of time, then this same payment cycle shall continue. This is something very, very common in many, many contracts. However, on that occasion, Balfour said, no, we don't need this. You know, it's covered. We always continue to pay. And I said, look, I'm a petty subcontractor's lawyer, so please add that up. And with a lot of kind of, even my client was dissatisfied with you, maybe because I was questioning such a big company's flaw. Anyway, that clause was added and we went on, and there was an overrun. And then we, because of the benefit of that, we continued to ask for extra payments every month. But what happened? Balfour went back to the employer asking for payment, and they said, no, the schedule has run out and you don't have a new date for interim payment. The case went to the court and Balfour lost. So you can see how important it is to agree at the very beginning a pre-contract review from a professional, because they're dealing with, if you deal with 10 contracts a year or 5 contracts a year, a professional reviews a contract almost on a weekly basis. So, and then the years of experience, they dispute resolution, they know the problems, so they can warn you. So it's a good idea, you know. And of course, when you are reviewing the pricing terms and the risk profiling, you should be very clear in your mind what are your obligations, where does the risk of mistake lie, if it's a contract, if it's a BOQ, it's a specification been priced, and whether there is an express term which changes the default position. So that's something you got to think of. And of course, there are other responsibilities like insurance, which is a different chapter you should take into consideration. Of course, the H&S responsibilities are frequently transferred from the contractor to the subcontractor. So all these, you know, if you have a tracker been set that these are my obligations, then dates have been added to it, you are in a better position and you'll be managing your affairs better. What are my obligations continue? That's, you can see why can't I demand extra payment? Meaning I have agreed to a certain sum and I find that my costs are more. Just as I've given you the example that you found that the ground conditions were different. You can't ask for an extra payment if you're a subcontractor if the default position applies, that site risks are yours. So just because there is a change in circumstance or you change a method, it doesn't entitle you to extra payment. Only extra payments are available if you have a change as defined under your particular contract, and that's been formalized to the procedure of change control management as defined under the contract. If it's a JCT contract, an instruction of change, if it's a variation, and if it's NEC contract, it's through a compensation event. If you fail to manage that document, either side, you'll be in difficulty. So be sure that you are dealing with it properly. And a parallel to it is, why can't I get extra time? You'll only get extra time than agreed if, again, if it's an NEC contract, if that's agreed via the latest program and the compensation event. And you'll only get that if you have notified appropriately a notice of delay, and under the contract, the administrator or the architect is under responsibility to give you a decision. If your application for an extension of time is not appropriate or you have never bothered to make one, you don't get extra time. And soon you'll see that the time is past and you'll be in great difficulty. Why are payment notices so important? Because it's interim payment regime as it is today under the Housing Grants Regeneration, Constructions Regenerations Act 1996. The terms are obligatory. The 2 payment notices are obligatory. So pair, meaning the contractor, may be giving a pay as notice, is under 110, is obligated to, or the payee, the subcontractor, may be asked to give a payee notice for his or her entitlement. There could be a third possibility, which is, of course, an application which may become a default notice. But once the notice mechanisms are passed, either there is a notified sum or lack of it. And the contractor can only avoid payment by issuing a notice of intention to pay less than the notified sum. So pretty important thing, keep that in your mind. Why record keeping is important? Because that's how you prove your entitlements, you know. And why must records include time-linked photographs? Please, 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 when you enter the site, you subcontractors, all the contractors, when subcontractors are entering the site, take a photograph. And when they're leaving, take an end of day proceeds photograph. Make it a compulsory requirement of daily 360 photograph or imaged report. Many, many problems will not be there if you do it. Well, I know CCTVs are used, but it's an easy method where this is where we have started and this is where we have ended, you know. Why do I need formal instructions and requests? It's because simple. It's because simple that that's the procedure through which you get your entitlement. Why I need to learn what I don't know? What sort of a question is this? This is a question that is very important from my experience for the subcontracting. Subcontractors assume a lot of things, lots of things. So they just keep on assuming that this is this, that is that. Please don't assume that you know everything about your contract. And when I say need to learn what I do not know, I am reminding you, as soon as you come across something, a word which you do not know or understand, take a list of note of it, be it a provisional sum. Even if you know what provisional sum is, many subcontractors, the contractors even do not know the difference between defined and undefined provisional sums for the contract purposes. So even if you know of, can appreciate there is something known as fit for the purpose, if you do not know what is the extent of your obligation under this contract for fit for the purposes for the goods and design services, please take a note of it. So what I'm saying is make a list, these are the things I don't know, and go to a professional. Otherwise, you'll be in difficulty at the end. A good communication system is a key to subcontract management. And normally it's a big problem because we don't have it. Also a filing system. Everything be filed on a daily basis. Records on a daily basis. It's a must. If you do not have every single person's everything and a diary and pictures and related instructions under a file on a daily basis, it's not a big deal. Just have a polypack of some sort and keep them date-wise. You'll save a lot of problems. And you've got to have in your mind clearly both parties a process flow of every items of works, you know. And of course, every time you're handing back something and eventually the final certificate is so very important because that's where you get your liabilities shifted to the other side. Well, I can keep on going for the whole day because so many contracts and subcontracts and problems, you know. So know your subcontract. Problem number 3, why am I not being paid? I more or less covered it earlier. Review the payment terms, what types of payment you have agreed to. Is it lump sum, remeasurable? Everything has an associated kind of process with it. So look at that. Review the pricing document if you can find one. Review the act and the scheme and how far your payment system and the process and the terms are compliant with that. And when you are making an application, what are you asking for? Are you asking for some measured work or for some variations? Different things apply. If there is a delay related claim, is there loss and expense or other claims involved? Is there's a delay claim involved, and have I made it in a timely manner? If there's a prolongation cost or disruption or prolongation claim involved, I had to work, there are issues on the site. If you have your record, you'll know there are issues on site and things were delayed due to my own fault, or I'm talking both for the contractor and the subcontractor. Have I notified, well, not only the contractor, if you are the contractor, if the notice requirements are to the subcontractor, and have you complied with it? And have you made your extension of time applications regularly? And if you are the contractor, have the decisions been made regularly? And is there a liquidated damage clause? And what are the implications if there is one? Now, finally, if you get into, and I'm almost running out of time, if you get into a dispute, which is a claim, and you need to resolve it, you need to find out what your dispute resolution claim talks about. Is this for money, or is this for time, or is this both? And then do not sort of start thinking about, okay, this is the delay, this is the liquidated damages, this is an extension of time, this is a loss and expense. With everything under one head, you'll be lost. Okay, take one box at a time, and if it's a variation change related claim, take a one track. If it's a time related claim, take one track. The first thing to achieve is to agree for both parties the extension of time issue. Once that's settled, you know what's the implication of the liquidated damage is, and then you go for loss and expense claim as well. Now, see what procedure you should go to. Is this the most popular ones nowadays are either going to cap or to adjudication. Of course, mediation is there as well. Court cases are the least possible chance. So review it, which one is better for you. It comes from what sort of evidence you have and what kind of dispute you have. And of course, when you are getting into an ADR process or making a claim, you always need to be commercially, whether it's commercially viable, and what will happen, or the impact of it in your next business. Do not just guess, fish, get excited. Get a proper advice from a professional before you proceed to a claim stage. And don't be emotional, be realistic. That's all from my side. If there are any questions, I would love to take a few minutes still there. If not.
Okay, it looks like you have answered everyone's questions there, but although if there are any questions, now is the time to ask, as Mohammed said. Alternatively, you will see on the screen shortly his email address, mohammed.haque@fletcherday.co.uk, and he is always happy to answer any queries you have that you didn't wish to ask in an open forum. Okay, we are back tomorrow evening, where we are joined by Brandon Silver and John Sharp, and that is for Construction Roundup, and then which will include details of potential impact on the construction sector from the COP26 conference from Brandon. And then we have several events coming on next week, including Construction and Insurance Case Law Roundup with John Sharp on Wednesday morning. We have Problems on Construction Projects. That's the second part of that from Richard and Brandon Silver on Wednesday at 6. And then we are back with the latest in Mo's his Adjudication Matters series. We are covering payment adjudication. That's Thursday evening at 6 p.m. As always, if you would like a place on any of these events, please email seminars@fletcherday.co.uk. Okay, right. Thank you very much, Mohammed. We will see you very soon. Thank you, everyone, for joining us. Have a great day, despite the awful looking weather. Thanks, Mo.
Yeah.
Take care.
Bye-bye.
Bye-bye.
And don't forget taking me off this